Thanks for joining me today. We're talking about joint wills and what they are. My name is Bill Henry. I'm an estate planning attorney with Robinson and Henry. So the idea behind a joint will is a good one. So basically it is normally made by a husband and wife in the one document. And what they want to do is say, if I die first, everything goes to you, but then upon your death, then it is going to go to our children or to whomever. And the spouse that dies first can rest assured that that is going to happen. Unfortunately, in practicality, there can be a lot of issues with joint wills. First is a will only is going to transfer probate assets. We've talked about this before, but basically probate assets are things that are going to transfer via the will through a probate. Sounds a little bit redundant, so let me dig into that. Basically, you've got your probate assets and you have non-probate assets like, let's say, your house or joint tenancy. That means two people are on title with rights of survivorship. It doesn't matter who's on title with you. If you have joint tenancy with rights of survivorship, it's going to go to that person, not who you put down in your will. Likewise, on your 401k, if you have a beneficiary designated, it doesn't matter who's in your will, who you say you want your property to go to in your will, it's going to go where your 401k says. So for example, if on my 401k, I say, give my $100,000 to my brother, and then in my will, I say, give that $100,000 to my children. Well, where's it going to go? Well, the answer is whatever you put on that 401k beneficiary designation. Also, when we do joint wills, we also have a situation where now the spouse theoretically can't do anything with the assets. They couldn't maybe sell the house. They can't give money away during life. And there'd be a lot of issues with joint wills. And I can tell you, I've never done one. So I personally, as an attorney, do not create joint wills. I always have two separate wills, one for each spouse. And I've been doing this a long time and done a lot of wills. So always two wills for spouses. And I really would tell you that that's generally the way to go. Yeah, so what do we do to solve this problem? If Bill, you're telling me that this joint will thing is a terrible idea, what do we do? Well, that's the classic use of a trust. So by using a trust, we can say to our spouse, hey spouse, I want you to have access to the money for your life, but then upon your death, I want it to go to these people, my children, for example. And that's how we can ensure that both the spouse that lives is taken care of and the beneficiaries, normally the children of the person that died, will also receive an inheritance. It's really important to do whenever we have blended families. So if we've got stepchildren, for example, well, stepchildren in Colorado have no right to inheritance under a will. So that means that if I give 100% of all my assets to my spouse and my spouse is the step parent to my children, well, what's going to happen is upon my death, if she now has access to all the assets, and if she can of course change her estate plan, or alternatively if she just loses the will, well, now all of a sudden it's not going to go to my kids. So moral of the story is, I know it was a little meandering there, but the moral of the story is that if we want to ensure that our kids or our loved ones receive an inheritance, but we want to make sure that somebody during life, like our spouse, is taken care of, and we want to solve that problem, it's just a great use for a trust. Again, I'm Bill Henry, a estate planning attorney with Robinson and Henry. If you've got any questions on this, feel free to reach out to me, and I'll talk to you next time.